Hello and welcome to Talks on Law. I'm Joel Cohen. Today we're joined remotely by a Second Amendment scholar, a law professor at Duke Law School, and the co-director of the Duke Firearms Law Center, Professor Joseph Blocher. The new test. Professor, what is the post-Bruen test for gun laws?
I can tell you how it originated and then maybe say a little bit about how it might apply going forward. But the origins of this test typically get tracked to a dissenting opinion on the D.C. Circuit written by then Judge Brett Kavanaugh. And in that opinion, he said that gun laws should be evaluated not based on any of the tiers of scrutiny, but based solely on text, history, and tradition, and when those run out, based on analogy to text, history, and tradition. Now, again, no circuit court adopted this test, but it did get votes in dissenting opinions, mostly by conservative judges across the country saying, no, we should do this instead of the two-part framework.
Yeah, why don't you walk us through that, Professor?
I'd be happy to, and I should say maybe by way of disclaimer that I filed a brief in the Bruen case in support of neither side defending this framework, so I'm a fan. But the two-part framework worked like this. There's Part one, or step one, the court would consider, does this challenge, the Second Amendment challenge, in any way reach people or arms or activities that fall within the Second Amendment? And that was a sort of historical question, right? There are some people, like felons and the mentally ill, who just don't qualify under the Second Amendment. Heller said so. There's other weapons, like dangerous and unusual weapons, that just don't count as arms for purposes of the Second Amendment. Again, Heller tells us that. There's just some things that don't trigger Second Amendment scrutiny at all, which, by the way, is how we do most constitutional rights adjudication, right? There's all kinds of things that involve the use of words, but don't count as speech for purposes of the First Amendment, whether it's libel or child pornography,
slander,
security, fraud. So that's step one, right? And a lot of Second Amendment cases got resolved at that step. For the cases that got on through the threshold and to step two, the courts would apply some form of means-end scrutiny, the sort of tiers of scrutiny that are familiar to anybody who's been through con law. And they would usually end up applying what we call intermediate scrutiny. In other words, they would ask, is this law substantially related to an important government interest? And the government interest behind gun regulation is always going to be regarded as important. It's saving lives, preventing people from being terrorized. Everybody on all sides of the gun debate agrees there's an important interest here. The question would always come down to tailoring. Does the law work well enough? Is it really directed at that interest? The old test had history in it, but it also considered contemporary costs and benefits. What the new test apparently does is say no consideration of contemporary costs and benefits, only history.
And I don't know. I mean, should I feel some pity for justices and for judges that now when they're deciding a case, not only do they have to understand the law and precedent and researching all the cases that are out there, but they also need to do a deep dive into historical analysis?
Oh yes, you should absolutely send them fruit baskets, send them coffee. They're going to be up late. I mean, there's a lot of. I would say that there's both too much history to read and not enough, because there's too much because there's not one single historical tradition. That tradition that's out there is regionally variant. I'll give you an example of that. That the regulation of concealed carry actually developed largely as a Southern phenomenon. We don't think about the South maybe as having the most stringent gun regulations today, but that's really where the pioneering was on regulating concealed carry, because it was thought to be like a dastardly way to carry guns. It was quote unquote unmanly, right? That assassin carries a gun concealed. But that was a Southern thing that had to do largely with preventing dueling and, honor-based fights and stuff like that. The North had a totally different tradition, which was much more restrictive of public carry as a whole. I don't know how a judge is supposed to pick and choose between those traditions. They're just different.
Or does the Southern tradition work in one circuit and the Northern tradition work in another?
I mean, exactly. What if the Fourth Circuit has we have different traditions than the Second Circuit, which covers New York. That would be interesting. Another division, and this is a big one and long-standing, is the division between regulation of guns in cities as opposed to rural areas. If you look back historically, we have a very stringent history of regulating guns in urban areas as compared to rural areas. And it's still true today, at least in the states that allow cities to regulate guns. But that's not like one thing. It's not like one tradition. So, a Supreme Court justice who's got to resolve a Second Amendment question, like what do they pick and choose from? And then to the point about there not being enough history, a lot of the modern gun laws we have didn't exist in any recognizable form in 1791. Even the category of felon, as we know it today, totally different in 1791. In 1791, they didn't prosecute people for domestic abuse in the way that we do, let alone take away their guns, right?
Because domestic violence wasn't a crime at all? Is that basically the...
You could be convicted of violent crimes, but domestic violence of the form that we, do it, and even federal criminal law just wasn't a thing in 1791 like it is today. But you could pick almost any example. I mean, certainly with classes of weapons, but also areas, like daycare centers, airplanes. I mean, we mentioned the airplane example in our brief, not to be sort of glib and funny, but just to try to wrestle with what does it really mean to designate certain places as gun-free zones, as sensitive places.
And let's say there's a state that puts in their law that places that serve alcohol are off limits. The analysis would be, let's go back and look at how in the 1800s, how courts treated bringing guns into saloons. Would that be the analysis?
That's what one reading of the majority opinion suggests. I think that would be a nightmare. I just don't think there's any useful lessons that you're going to get from history about the question if it's pitched that way. I mean, this is the tricky thing about these historical tests, is they're going back to what we were saying earlier. It's so manipulable, right? Like, you could phrase the question a different way and say, let's look to history. Did the framing generation prohibit guns in places where they were especially dangerous? And maybe they had a different view of what dangerous places were, just like they had a different view of what groups were dangerous. I mean, in the founding era, they disarmed Native Americans, people who wouldn't take oaths to support the United States, because they were thought to be dangerous. We don't do that anymore, thank goodness. But they also did not disarm domestic abusers. We do. Our understanding of what dangerous groups are has changed, and maybe the same is true for places, for place-based restrictions. I mean, there were restrictions back then on carrying guns around on election days and near polling places and near courthouses, and so you could kind of reason from that. But I don't know how you apply that to, a subway challenge, right? It's going to depend on how the judge decides to slice the historical record, frankly.